Hello everyone, welcome to today's current affairs session of Civilspedia. The topics we are going to see is Medical Termination of Pregnancy Act, Annual State of Working India Report, Loo Review Campaign, and then Section 497 with respect to gender justice. And first one is Medical Termination of Pregnancy Act. So what is the important things of this Pregnancy Termination Act is this unsafe abortion. That is a huge important thing that we have to notice under this Medical Termination of Pregnancy Act. Because this unsafe abortion is the third most lethal cause of this maternal mortality, and it alone constitutes 8% of the total maternal mortality that is happening in India. And in India, only 22% of abortion is happening through this safe hands of health facility. The rest of the 78% of abortions in India is happening through this unsafe manner only. That leads to this 8% of maternal mortality. So that shows why this much of huge amount of, that is almost 3/4 of abortion is happening in India in an unsafe manner. The reason behind is, first and foremost, is accessibility. So first and foremost thing is accessibility. So accessibility is, in India, the doctors and the patient ratio is 1:11,000. That is, for the one doctor, we will have 11,000. For the 11,000 people, we will have one doctor only. And this is also is more skewed towards this urban area. For example, the urban-rural ratio is 3.8:1. That shows 3.8% of doctors in the urban areas, while 1% of doctors only working in this rural area. So that is this kind of more skewness of this urban-oriented, and more in this urban areas leads to this rural women don't have any option to have this safe abortion. So their mortality rate, maternal mortality rate has been rising in this rural India. And second important thing with respect to this unsafeness is affordability. So more and more women don't have that much of affordability to go to the private hospitals to have this safe abortion, because public hospitals is providing this abortion facilities, but the number of doctors that is available for this abortion is very less. So because we need to have more specialized doctors to have this abortion, so that is not available right now. So more and more we have to go for this private hospitals only. We have to depend on it. That shows that is going to increase the medical expenses of these people also. So more people don't have that much of affordability. So that leads to this more and more maternal mortality. And third important thing with respect to is awareness. So a recent survey has been conducted in Jharkhand and Bihar that shows only 2% of women know about that up to 20 weeks of this pregnancy, they can have this abortion as a legal. So very less awareness of this happening within this Indian women about this abortion. So because of that itself, they are going for this illegal manner of abortion. And fourth important thing is social stigma that is attached with this abortion. So they cannot go openly for this abortion to have this social stigma. So they are going for this unregulated manner. So these are the four reasons. That is why we have 78% of abortions happening in an unsafe manner. And with respect to this MTP Act, that is Medical Termination of Pregnancy Act, till 12 weeks of the pregnancy, the one single doctor's consent is enough to have this abort. After this 12 week, that is from 12 week to 20 weeks, we need to have 2 doctors' approval to go for this abortion. So that too, one criteria has been put out. That is, if the girl has been pregnant because of sexual harassment, or the pregnancy will lead to be lethal to this child or to the women, or if there is a pregnancy due to this wrong things of or failure of this contraceptiveness. On this 4 criteria, if there was pregnancy, then it can be aborted. So beyond the 20 weeks, then it has to be go for this court only. Then it only decided. But what is the problem of this thing is, most of this genital disorders or genetic disorders will be found at this 18th week of this pregnancy only. So after this 18th week, we will have only 2 weeks of time to decide whether to abort it or not. So that much of pressure will put on this family of this child, whether to abort it or not. That shows the time lagging to take the decision makes that it has to be go to the court to have this verdict of whether to abort it or not. That makes the complications in this medical termination. That shows this most abortions are happening in an unsafe manner. And another important thing with respect to this unsafe abortion, why it is happening is, to have, as per this act, we need to have a specialized allopathy doctor for in gynecology and obstetrics. And with respect to this, and they have to have specialized training program also. Only after that only they can involve in this abortion process. But already we have shortage of doctors, and that is also more skewed towards urban area And within that also we need to have this much of a specialized allopathy doctors, then only we will have this abortion. That makes that very minimal amount of doctors only available to have this abortion, safe abortion. That's why many of the women are going for this unsafe abortion. And this act is primarily aimed to stop this sex selective abortion. But what is reality is going to have is more and more abortion is getting curtailed by this act. So instead of a sex selective, the normal abortion itself is going to be hurdled, or it's going to be very tough to under this act. So that only more and more women are going in an unequal manner. And what are the things we need to do to have this safe manner is, first and foremost is we have to deregulate this regulation. So from the state level, we need to have a district level regulation of this abortion centers. And second thing is we have to amend this MTP Act. So recently we have this amendment, we have proposed the amendment in this MTP Act that more and more of this licensed medical practitioners have to be involved in this abortion process, like ASHA or auxiliary nursery midwives or Angadi workers, how we can utilize them, the potential of that persons to be useful for this abortion activities. That is the thing we have to amend in this MTP Act. And apart from that, then how to involve this more and more NGO peoples, because the role of NGOs in the health sector is more and more positive things. So how we are involving this NGOs in this abortion process will make India to have more and more of a facilitated abortion activity. An important thing that we have taken the step is the sexual and reproductive health services has to be addressed properly. So we have initiated this RMCH+A program initiative. That initiative is nothing but it is a reproductive, maternal, newborn, child and adolescent health strategy. So if we started to follow this strategy properly, then it will reduce this maternal mortality rate, and that way we will achieve this sustainable development goal also. And another important thing with respect to this MTP Act is it is in controversy with this PCPNDT, that is Preconception and Prenatal Diagnosis Technique Act, and then POSCO Act, that is Protection of Children from the Sexual Harassment Act. These two acts are in contradicting with this Abortion Act. So that only more and more activities are not coming under this recorded health facility, rather than it's going in an unequal manner. So next important thing is this annual State of Working India report. This report has been launched by Asim Premji University. What does this report says that the central message of this report is we have to meet this Gandhi and Ambedkar has to meet this Kuznets and Lewis. What that said that is Gandhi indicates that environmental sustainability is ultimate need, and then Ambedkar shows that it is a social justice, and this Kuznets mentioned that the shift of the labor force from this forming industry into non-forming sector. And with respect to Lewis is the shift of workforce from this less productive sectors to this more productive sectors. So what is this report has central message is when this environmental sustainability along with this social justice, if more and more workers has been transferred from or shifted from non-forming sector to non-formal sector, as well as from less productive sector to the more productive sector, then the working capital of the India will be more good, and it will helpful to reap the harness of the potential of demographic dividend. And the report has said that for every 10% increase in the GDP, we have only less than 1% of employment opportunity is creating. That shows the GDP rate is increasing, but in that level, the employment rate is not increasing. That shows this employment elasticity. The employment elasticity is nothing but it is for the 1% increase in GDP, how much percentage of employment has been increased in the country. That the ratio is called as employment elasticity. That employment elasticity has been decreasing trend. So for example, in RBI from 1972 to 2012 shows that the GDP has been raised from 4.6 to 6%, but this employment elasticity has been reduced from 0.57 to 0.18. That shows we are growing, but the growth is a jobless growth. So, and the report also said that among this regular workers, the 57% of regular workers are earning less than 10%, and 59% of casual workers, that is informal workers, are earning less than 5,000 rupees per month. That shows this already the people are working as the underemployment. That is one of the worst scenario that is with respect to this working India. And the one positive thing that the report has said that is there was narrow wage growth between this organized sector and unorganized sector in the manufacturing, because right now the wage has been increasing in this unorganized manufacturing sector, so that the gap between this organized and unorganized manufacturing sector has been narrowing down. And next topic is Loo Review Campaign. This campaign has been launched by Ministry of Housing and Urban Affairs along with this Google. And this program comes under this Swachh Bharat mission of Urban. And what this campaign is nothing but it encourages the local guides to rate that public toilets, rate and review the public toilets on the Google map. Like this, if we go and the rate, there is a public toilet here, how the public toilet is maintained, what is the usages, how the people are using it, what is the condition of that. Because more and more we are creating the public toilets, but what is the usage of that? What is the quality of maintenance of that is the big question mark. So by having this kind of a real-time cross-check, we will get to know what is the ground reality. Because we are spending more and more of amount of resources on this Swachh Bharat mission. So what is the output of the Swachh Bharat mission is a big question mark. So by having this kind of virtual reality things and real-time things, we can get to know whether the country's money is properly utilizing or not. And this local guide, they are nothing but they are the people who are ready to share, review photos and the knowledges of them to explore more and more traveling in the country. And the next important topic with respect to mains is this gender justice of section 497. The recently Supreme Court has struck down this section 497 of IPC and section 198 of CRPC. So why the court has said that this law, which is almost 150 years, this law has been prevailed. Why this law is not giving this gender justice? On what stands that this law is not giving a gender justice? So first and foremost thing the court has decided is whether this section 497 is a constitutional valid or not. That is the biggest question in front of the Supreme Court. The court said that why it is not constitutional valid for this section 497. First instance they have taken is as per this Article 14. The Article 14 is nothing but it says equality before law. That is, before law, both the men and women are equal in all the circumstances. So under this criminal law, the criminal law shows that gender neutrality in all the scenarios, whether it is a robbery or any other murder, killing, whether men or women is involving in any criminal activity, then the gender neutrality will prevail. That is what the men is getting to get punished. That is the amount of punishment will be given to this women also. But this section violates this one. For example, first and foremost thing is, if a married woman will have an illicit affair with or extramarital affair with another person, then that extramarital person only is going to, that third party person is going to get punished, while the woman is not going to get punished for the same activity. So one person, a criminal offense, for that one person is getting punished, while the another person is not getting punished. Because in this scenario, it was seen as women as a victim, while the man, the third party person, was seen as a seducer. So the seducer is going to get the 5 years jail along with fine or both. So why this has been taken in this stance is, it is based on the society's pre-assumption during that period of 150 years before, because it was started in the British era period on that Victorian law basis. So that law shows that women is a victim. Women doesn't know about the consequences of that. The other party man is the seducer that is taking away the wife from that husband, legal husband. So as per that law, it shows that the man is a seducer, so he has to be punished, while the woman is a victim. But the reality right now, the society has changed and women has been more empowered and they started to have more knowledge of that. So right now we cannot say that women is ignorant and women is a victim. So what is the consequences of having an extramarital affair? The women doesn't know. Like that we cannot say. That shows that women is not the victim. Women is a part of the offense. So we cannot have women can go as a free while the men alone has to get punished. So it shows that the gender equality has been broken down in this section 497. And second stance why it was violating this Article 14 is, that is right to equality, is while the married man will, if the married man is going to have affair with an unmarried woman, then the wife of the married man cannot sue a case against this. So this shows that if take example of X and Y, so X is a woman and Y is a man, they both get married, and another couples like A and B, A is a woman and B is a man. So if this Y is going to have affair with this A, then the B can sue this Y. He can put a case. But this X cannot put a case on the husband that he has an illegal affair. So that shows that women is violated. That's the right of the women. This X women is violated. While this right of the men, B alone is get agreed. That shows this B can sue that person Y, while this X cannot sue the person of Y. So the wife cannot go against this, put a case on this husband. while the husband of that another woman can put the case. So it shows that the women cannot prosecute. So the gender equality has been violated here. And third important thing why violating is Article 14 is the right of hearing, which is the principle of natural justice. In many occasions, the woman, the wife is not allowed to have this right to hear. So that shows that based on these three circumstances, the Article 14 is violated severely in this section 497. And next important thing why the court says that it is not constitutionally valid is as per this Article 15.3, which shows that it is an affirmative action or positive discrimination for women, that a state can have prohibit the discrimination based on the sex, gender, and caste, religion. While this shows that women can have positive discrimination, but this article of section 497 says women can go as a free hand. That is, she is not going to get punished. She is not punished as an abater. That is, abater is nothing but a person who is encouraging another person to do a crime. So women is not get punished for this. That shows this gives this article. As per this article, the women are getting privilege to do the crime as per their wish. Because they are not going to get punished. That shows this article has been violating, because that article has provided for this positive discrimination only, for the growth of the women, not for allowing women to do a crime as per their wish. So as per these two articles, the court says that it is not doing a gender justice to both men and women, because in one case men is also get affected and in another case women is also get affected. So it is not giving a gender justice for section 497. And apart from that, the language that used in the section 497 itself said that if an activity has been considered based on the consent of the husband, then it is not a criminal offense. Without the consent of the husband, if the married woman is going for have a relationship with another person, then only it shows the offense. That shows a same activity. If it is happening with the consent of the husband, it is not an offense. But without the consent of the husband, then it is an offense. That shows the consent of the husband is the prime soul of this section. That motivates that it is just nothing but treating the women as a property of the men. That is, the women, the wife, as the property of the husband. Thereby, it reduces the individual identity of the women. The independent identity of the women gets tattered so much. And along with that, it also says that it projected that women as a subordinate to the men, while our constitution itself gave equal status to men and women. But this section is providing women as a subordinate to the men. And another important thing we have to notice is most of the media has projected that as per this recent court's verdict, the adultery is removed as a criminal, is removed from this criminal offense. So anybody can have this illicit affair, then it is not going to be sued. Actually, the scenario what this said is the section 497 of adultery, that means a person, a married woman is going to have a relationship with a third party person with the consent, then it is not an offense. But if we take the scenario of a section 498, that is, if a married woman has been seduced or has been enticed by a third party person, then there we can sue a case against that third party person. But if with the consent of the women this scenario is happening, then we cannot put a case on that, because the court itself says if incident is happening with the consent of the women, then the scenario is a different case. While without the consent of the women, if there is some activity of a third person involving in the wedlock manner, then we can have the section 497, which is a criminal offense of seducing or inducing a married woman. So this section 497 of adultery, the Supreme Court emphasized more that it is happening with that consent of both the people, that is the married woman and the third party person. So if the consensus of both the people is involving, then it cannot be taken as a criminal offense, because both the people are with that consent only it's involving. So why the adultery is not taken as a criminal offense? The court has said. So first and foremost thing is the more and more of a ground reality, because this section has been abused or misused by many people. Because for example, if men and women get married and they are going to apply for this divorce, and in India the divorce is going to take a longer period also. So within that period, if the woman is going to have some relationship with another man, then the husband who has applied for the divorce can take it as a scenario and they put the sue a case against this third party person. So most of the scenarios is happening in that manner. So this adultery is wrongly used, because this woman right now don't have any relationship with that husband. So right now she is alone only, but the divorce is not granted. So in that cooling period, if the woman is going to have another person's relation, then it is cased. It will be cased by the husband. Then the court has said that we cannot take that as a case for this criminal offense. And second thing, the court has said that this problem can be solved through talks. If it is not cannot be solved through talks, then we can use this adultery as a ground for this divorce. Then get divorce and it has to be solved. So these are the based on these two things, the court has said adultery need not to be taken as a criminal offense. So, and the court itself has said that right now the important thing what they have said is it is up to this legislature to decide what is the need of the society, how the society has been transforming. As per the needs and demands of the society, it is up to the legislature to create the law, how to handle this adultery related things and how to handle this bigamy and more things of marriage institution related problems. And the court just say, it will see what is the constitutional validity of that law created by this legislature. Because if legislature is going to create a law to have more and more institutional, family institution related cases, then this judiciary will see whether it is under the constitutional provision, whether it is giving a gender justice or it is not affecting the basic doctrine of the constitution, then it will be get into allowed. So right now the role has to be played by this legislature of to handle this marriage related institutions issues. With that, we will end today's current session. Thank you. Share, comment and on this channel.